How you doing, Scott?
Hey, Carlos, how are you?
Things are good.
Good. Well, I'm excited to meet with you now to do the first of our quarterly programs for the Legal Chat for the Self-Storage Legal Network for the year 2025. Well, it's good to chat with you. I know there's a lot going on in the industry. It's hard to come up with topics that there's so many things people want to talk about. But I know we've discussed today talking about a few issues that will impact storage operators around the country, and I hope it's helpful to folks.
Well, one thing that's been on my mind, and I think it's probably always on your mind, is going to court. And the reason I think that's kind of an interesting area is self-storage operators, even though they're landlords, don't go to court that often because they have the lien remedy. And I mean, that has been truly a game changer for an industry that if they had to act like other landlords with every single tenant who didn't pay rent, they'd be living in the courtroom. But there are other reasons why self-storage operators have to go to court or may be involved in the court system.
Well, it's interesting. I certainly, from my perspective, I guess I'm glad that sometimes they have to go through the court system as compared to the self-help remedy of a lien foreclosure. But it's never a happy time for an operator to have to go through a legal process. I mean, it's not only costly because of the lawyers involved, but it's time intensive and it's distracting from an operator's regular daily business. So I always feel a little bad when they're caught up in the court process. Sometimes they don't have any choice.
No, and fortunately, there aren't a lot of situations, and they don't happen that often. Probably one of the ones that does come up they'll run into it from time to time is when they have tenants in the military. And a military tenants, both the tenant and the tenant's spouse, are protected by the escaping my mind.
Service Member Civil Relief Act.
The Service Member Civil Relief Act. Yeah. Where did that go? And one of the things that it does is if a landlord or a self-storage operator or other business, towing companies is another business that have to deal with this, have a lien on property that belongs to a person in the military, they can't use what is normally a self-help remedy. Those statutes require that they file a lawsuit in state court, even though this is a federal law, to enforce their lien. They have to get a judge's order to go forward. Have you dealt with this situation before, Scott?
I have, and it can be very frustrating when a operator is not being paid, chooses to go through the foreclosure process, and then realizes their tenant is active duty or their spouse or dependent is active duty military. So they're restricted to the limitation of being able to enforce that lien unless they have a court order, like you said. And now, one little caveat to that I know we've talked about in the past is under that same statute, there is an opportunity at the engagement of the landlord with the tenant to have the tenant execute a waiver of those SCRA rights. I mean, have you seen that be used by self-storage operators from the get-go to have them sign the waiver of that court-required foreclosure?
The short answer is yes, but you have to do it right because the law imposes certain requirements for you to have a valid waiver. And item number one is that it be a separate contract from the rental agreement. Because if you just embed it in the rental agreement, it's not enforceable. It also, there are type size requirements on this agreement. And so you got to make sure, and you also need to be specific. You want this agreement to be very clear that the service member is waiving rights under the under the self-storage lien statute, that you would normally have to go to court to enforce it as long as they are active duty military, and they're waiving that right that they have under the Service Member Civil Relief Act.
Yeah, so absent a waiver or some other voluntary agreement for the tenant to settle the account and move out and close the account, the operator is going to be in a situation where they're going to have to enforce their lien right through court order. The reason you had asked if I've done it, the answer is yes, but it's very frustrating because as part of the court process, most judges want to see successful service on the service member in order to proceed with the court action. And sometimes getting service or the physical delivery of the action to foreclose on the customer can be very hard because they're in the military and they may be deployed somewhere else. So there's a whole other level of complication for the court action with SCRA. But I think you bring up a good point. Whereas normally we have a lot of self-help remedies and self-storage, the SCRA compliance with the court order and therefore having to go to court for that I agree with you, is probably the number one, quote, going to court exception there is for self-storage. How about the second one? What's on your list for number 2?
Well, the other item that causes, you don't necessarily end up going to court, but you have to deal with the court system, is bankruptcy. Because when the tenant files a bankruptcy, as soon as that petition is filed, there is an automatic stay on all state remedies. The liens, the lien remedy, the self-storage lien remedy, is a state remedy. And now the space and the contents are under the jurisdiction of the court. Now, the one thing that the operator may need some help on this is to realize that there are different chapters of bankruptcy, but the stay goes into effect with all 3. The typical ones you'll run into are 7. That's a liquidation. Basically, your tenant, you've just found out your tenant has more debts than money. And 2, you've got an 11, which is a business type bankruptcy, and that's generally referred to as a debtor in possession. So the bankrupt business actually can still deal with its affairs, but it's protected from debt collection while they try to rehabilitate, straighten things out, or finally decide, well, the only thing left to do is to go into a 7. And then you have the 13, which is similar, but that works for individuals. And so an individual, they file this, and they're supposed to, under the protection of the bankruptcy court, work out a rehabilitation with the creditors over their debt situation. So those are the 3 that you're going to deal with, and you've probably dealt with trustees who oftentimes have ultimate control over what's going on, regardless of the chapter.
Right. So you're absolutely right. So if a tenant files one of those chapter proceedings for protection, the court puts a stay on any creditor action until the court otherwise lifts the stay and approves the enforcement, or other arrangements are resolved through the trustee and the attorney representing the tenant, if there's an attorney representing the tenant. So, the process of, like you said, having to go to court if a tenant files bankruptcy is a sort of a last resort. There is a legal process that takes it outside of the self-help remedy of the lien foreclosure, and maybe a resolution could be reached with the tenant, debtor, their attorney, the trustee, to abandon the property or recover the property, or failing that, ultimately a motion has to be filed with the court to lift the stay to foreclose on the lien. And that takes time and money. And, as you said, it's federal court trying to enforce a state law process. So it can get complicated. Companies cannot file an action to lift the stay themselves, they must be represented by a lawyer in federal court. So the time and expense pops up again if you're in court in a tenant bankruptcy.
Well, one of the things that if a bankruptcy is filed and the stay goes into effect, and I mean, you may be getting paid rent, so it may not be an immediate issue. But assuming that you're not, don't ignore the situation. I mean, one of the things that you might want to do is if there's a 7 going on, the person who essentially controls that space, controls that tenancy, is now the trustee, and communicate with the trustee and see. And as Scott said, the contents may be of such a nature that the trustee has no interest in them and is willing to basically, release your space from the overall bankruptcy situation and allow you to go forward with your lien. It may contain nothing. The only thing it may contain is what's called exempt property under the bankruptcy statute. And so the bankruptcy is not able to deal with that property at all. You might be. So one of the things I kind of tell operators is if you got a bankruptcy and it's, you might want to tell find out what you're dealing with in terms of contents. And if you've got the crown jewels in there, tell the trustee and say, hey, look, this is the crown jewels of this bankruptcy estate. You want to pay the ongoing rent, store it until you can dispose of it. Alternatively, you might, and probably more commonly, the property has little or no value to the bankruptcy estate, and again, maybe you can get the trustee to abandon the property with respect to the bankruptcy, and you can go about your use your lien sale remedy. In the 11, there's really, if it's a viable business, there's a good chance you'll just be an expense of the bankruptcy. I don't know if you've dealt with those, Scott.
Yeah, no. I hate to say it, but if there's going to be a bankruptcy, you're hoping it's a Chapter 11 and it's a business. Maybe you'll get your money out of it as a result of that. But let me bring up 2 practice pointers for operators that are dealing with bankruptcy. First one. There is commonly an interest by the trustee to inspect the property in the unit, and that is their right. And you should not hesitate when a trustee contacts you for an inspection to allow the inspection. We get a lot of calls about, whether they're allowed to go into the unit even though the unit's in default. So obviously, the tenant through the trustee has the right to inspect the property. And the second one, and I know you love this one as much as I do, is when the tenant files bankruptcy. Do you stop charging rent to that tenant when you get notice of the bankruptcy?
That's one of the more subtle questions of bankruptcy, because the bankruptcy stops collection of pre-bankruptcy debt. What you have now is an ongoing expense of the property being in the thing. And I certainly keep track of it. Whether it becomes collectible after discharge, I've never been 100% certain as to how you deal with those unpaid expenses during a bankruptcy, especially when the bankruptcy has gone on for months, because then you'll get a discharge notice. And I think when that happens, the first thing you want to make sure that you do is tell the tenant, you've got to start paying rent now.
Right.
Because there's no question that rent is owed. But if I'm going to lien and they still don't pay, that as far as I would be concerned, that property, the non-discharge debt, i.e. the rent that accumulated during the bankruptcy, I think the lien secures that debt.
Well, most important for me is I want operators to know that they aren't restricted from charging the rent. Now, what they do with that debt, whether they seek to foreclose on the lien while the tenant's still in bankruptcy, I still believe a lien would have to be approved by the court, and the stay would have to be lifted, even on a post-petition debt. My practice pointer for the operator, though, is just because someone files bankruptcy doesn't give them the right of free rent from that point forward. So absolutely continue to charge the rent. There is a delineation between pre-petition and post-petition debt, but that can be figured as part of the filings with the court. Just don't be afraid to charge rent and late fees associated with a post-petition filing.
Well, one of the problems, though, is they'll just get this notice of discharge and they'll get no explanation of any of what's going on.
Right.
And so, and I can tell you, I don't know, maybe it's better on the East Coast. Once a bankruptcy is discharged, trustees aren't that communicative.
No, I agree. It's definitely a complicated issue and something, unfortunately, that operators need to deal with. And we've seen an uptick in tenant bankruptcies in this sort of pseudo recessionary period. So I think it's going to happen more and more. All right. Number 3 on the list of having to go to court when you can't use your self-help remedy. And I know this is near to dear to your heart, is those states that once you trigger the lien, those darn tenants have a right to object and require a trip to the courthouse. So let's talk a little about California first.
California is a bit unique, and it's unique because it's so easy for a tenant to do if they want to do it. They don't do it often. It's not it's probably less than 95% of the delinquency cases that these, what we call the dreaded opposition to lien sale, comes back to the operator, but when you get it, you've got to deal with it. And the first thing you get to do is they have one obligation that you can actually probably assess on your own. And that one obligation that the tenant has is they have to give you a physical address where they can be served. The one thing, it used to be this tiny little form and the person just had to sign it. It was terrible. And the operators didn't know where the tenant was. The legislature changed it, and they have to provide a physical address where they can be served. And if they don't provide that address or keep it updated, their declaration can be voided, actually. It's the only area, address is the only item I would ever criticize, I would ever suggest that a storage operator make a self-assessment, because it's something that's obvious and provable relatively easily. It's blank. That happens a lot. Sometimes these addresses are vacant lots. And that's one reason why I kind of like using a process server if there's an address there, because the process server can give you an affidavit that I went to the address that the tenant that was provided in the declaration of opposition, and the tenant, and it was not a premises occupied by the tenant. And so you can actually get something from them, and that does happen from time to time. And again, that is a circumstance where you could go forward with a lien sale because you have a non-compliant declaration in opposition to lien sale. But again, it does happen. When you get one, the other thing you might want to do is just talk to the tenant, because the one thing they often don't understand is where it leads. It leads to the courtroom, and they may not want to go there. And there is a procedure that they can withdraw it in writing. Other states have it too. Nevada has it. But we love that, and we love Nevada because Nevada makes the tenant, gives them 30 days to file the lawsuit.
Yeah, the burden's on the tenant to file in Nevada, whereas the burden's in California is on the operator to file, right?
Yeah, it's just so, and it almost where California it's maybe 2 or 3%. In Nevada we find it's less than 1% that actually go through those steps.
Well, there are other states that have this opportunity. I'll give an example. North Carolina has a provision where the tenant can make a objection and force the operator to file an action to enforce their lien. But let's not forget just the common law remedy that a tenant could seek to file a TRO or injunction in response to a lien action, which would put you into court. And you know, there may be other situations where there's a generalized objection to the lien, and the discomfort of enforcing a lien that's subject to objection in terms of the debt that's owed or the rights of the operator would probably motivate an operator to file an action in court to do an eviction or an order for enforcement of the lien in lieu of doing the self-help, so that you get a court order that you can rely upon. So there are situations, you know, both statutory and sort of circumstantial, where a court action to enforce the lien, the monetary default, maybe be the best solution for the operator, the safest solution.
It's actually the one thing I do like about the declaration in opposition, because there is the notice, what we call the notice lien sale goes out, and it's included with that notice, and there is a procedure, a state procedure for stopping the lien sale. And I'm probably more reluctant. I'd be more I'm more reluctant to stop a lien sale because somebody says, well, I don't want you to sell my property in California because there's a procedure, than states that don't have a clear procedure for stopping it. I think you have to be a little more careful if you start getting pushback in states with no procedure. So Nevada, California, a few other states that have this procedure, while it's annoying, there are certain advantages.
I think that's true. Well, you know, this trip to court is just part of the cost of doing business. I mean, I have these conversations with operators a lot, that they look for the easy road of solution. Sometimes it's not easy. And when you're dealing with a facility that has hundreds and hundreds and hundreds of units, it's pretty likely that 1 out of 500 may end you up in court. So, you know, but trust your instincts. Do the right thing, stay out of trouble on the court process. Yeah,
and I think that's the real, the real focus of this, is that you may have to go to court, but it's rare. And always keep in mind, you are much better off than all the other landlords out there who don't have self-storage, because their procedures are a lot more difficult, especially when they're dealing with residential property.
All right, so let me turn the page on another topic for purposes of our chat, because as part of the Self-Storage Legal Network, as you know, we get questions all the time on lien issues and rental agreement issues and issues like this with regard to objections to enforcement of lien. The topic of search and seizure comes up a lot in terms of the questions that we get from subscribers. So let's talk a little bit about the circumstances where there is a requested search by law enforcement, but the unit's in lien status. What do you think?
There is actually a fair amount of case law surrounding this area, more so, in residential and other types of property, where it's not necessarily lien status, but where the tenant is actually in fault, is in default. And when that occurs, the landlord may have certain rights to the space that they don't have when rent is being, is paid in full. And and so if a tenant is in the lien process, they're moving towards a public sale. And I want to emphasize the word public, because eventually the public is going to be able to look at those contents, possibly online or maybe at an in-person thing. And so obviously at some point the landlord takes a great deal of control over the storage space. And so in those circumstances, the landlord probably has permission, authority to allow the police to search a space, even if they didn't have a warrant. Now, it's discretionary. And my feeling has always been, if you're far along in the process, you've cut the lock, you're going to probably expose the property to some type of lien sale. let the police have a look. I mean, you do want to have a good relationship with local law enforcement, because there may be a time you need their help. I would emphasize that, but on the other hand, if the lock's on the door and the rent is being paid, that's a situation where a warrant is really in order, because the property isn't in the landlord's possession. The landlord has no control over the property. And the only person that can consent to entering the storage unit is actually the tenant. And the landlords say, oh, yeah, go ahead and search it. It's meaningless. So I think, I worry about that. Scott, have you ever dealt with a situation where the police come in, they don't have a warrant, but they have information about the tenant that they're on probation or parole, and that that is part of that process, the tenant has consented to a search of their property?
Yeah, so I think it ties along with the exceptions when someone's on probation and parole and they've consented as part of their probationary status to the release of certain of their constitutional rights of search and seizure. It goes to the same issue I think you were just talking about. When a landlord has control of the unit pursuant to the statutory right of lien, the expectation of privacy that a tenant otherwise has concerning what they're storing in the unit goes away. So if the tenant is in default and the unit is in lien, and certainly, like you said, the operator's already cut the lock and has possession of the property, maybe he already took pictures of it, there's no violation of the tenant's expectation of privacy if the police come to that facility, because the operator's already been in the unit. It's already been exposed to the public. So I think that's a clear exception to the search and seizure rules, as well as what you've just identified, which is the representation by law enforcement that the tenant, the named tenant for which they're searching, has released their constitutional protections because of their status, and they seek the right of entering the unit. Now, here's the tricky part. What would you need to feel comfortable other than law enforcement representation concerning the right to enter? And we always get into this issue of, we don't want managers creating any obstruction of justice by denying law enforcement the right to enter when law enforcement says it has the right to enter. So how do you balance those interests of keeping a manager out of jail and the demands of law enforcement?
Well, actually, sometimes the police have a form for that, where they actually have a consent as part of the, the probationary process. This person's under investigation. They know he's on parole. They know he's on probations. They've consulted the probation, and they have it. And I've actually seen them present that a form to the storage operator. We have a consent form from this particular person because of their probation or parole status. It gets a little trickier when you're working with just the representation of police and no other information, and that's where you start wondering what to do. But in the final analysis, and this is, Scott, always advice to storage operators, don't argue too vociferously with men and women with guns.
Yes, I think if they demand access, certainly there's other exceptions under the law, exigent circumstances, and you don't want to be the person that blocks that. If the police provide that, create an incident report, get the badge numbers, get a card from the law enforcement, get information as to who's making the demand. But at the same time, you could clearly, absent these other exceptions we've been talking about, if you get a demand to enter the space without a search warrant, you certainly have the right to ask for one. And if in fact there is probable evidence to enter the unit, it should not be that hard for police officers to get such a warrant. That it should be somewhat readily accessible as part of an active investigation for someone to be able to access a warrant, unless there's, again, if there's exigent circumstances, sort of emergency situation, and they demand access, we tell them to get out of the way. You don't want to block that entrance. I was going to ask you about surveillance. If a law enforcement officer comes to the facility and says they want to surveil a particular unit, absent a search warrant or subpoena, how cooperative do you think an operator should be relative to giving surveillance rights to law enforcement?
My general view is that unless there's a good reason not to be, you want to cooperate with law enforcement agencies, and if they want to surveil a unit, the one thing you do know is that the common areas are under landlord control. And you can determine who, if they want to have somebody hanging out in a common area. That's really a decision of the storage operator, because that's their property and under their control. And the spaces are locked and closed, and the police aren't violating anybody's privacy. And just to look around what's happening on a facility, at least you know that it's unlikely to be a burglary that night.
I agree. Well, we've covered some really interesting topics today, but as we always close with our legal chat, I want to talk about the fact that it is the beginning of spring. Always with the beginning of spring comes baseball season. So do you have any prognostications for baseball 2025? Who are we going to see in the World Series, Carlos?
Giants are 5-1 so far. They've got a record equivalent to the Dodgers. I can't see how they're not in the World Series.
And my Braves are 0-7. So I don't know if that looks very good for our home team this year, but spring always brings eternal, right? Spring's eternal.
Yeah,
So
I was skeptical. They had a great spring, and then they took 2 out of 3 with Cincinnati, and I'm thinking, well, this is looking pretty good. But you never have faith in the Giants. And then they swept the Astros, and I decided, well, maybe this year is the one.
I like the attitude. All right, and the last thing is, of course, I get to ask you this. In a few weeks, you'll be traveling the world. Where are you off to, Carlos?
Well, this year, leave in the middle of the month. We're going to Edinburgh. So I'm practicing my burr, and then off to Paris. And I'm hoping for good food, good museum exhibits, country houses, and great gardens.
Wow. And a little wine along the way, I hope.
A little wine along the way. I could put that in the food category.
Well, I love chatting with you, both legal and non-legal. And this brings us to the end of our first quarterly legal chat for the Self-Storage Legal Network for 2025. Hope to see everybody at future state meetings and, of course, in the fall. And we'll talk about this again before the fall happens, the 50th anniversary of the SSA and the conference in Vegas. So we're looking forward to that. It's down the road, but something to look forward to. Thank you all for joining us on the Legal Chat for the Self-Storage Legal Network. We want to thank Lighthouse Storage Solutions for producing this with us with the Self-Storage Legal Network. Again, you can ask questions for us for our future sessions that are going to be on YouTube. We're going to do these 4 times a year at the email below. And certainly you can reach out to Carlos and I via our emails if you have other questions about what we're doing. And certainly you can reach the Self-Storage Legal Network at www.selfstoragelaw.com. Again, thank you.
Thank you.
We'll see you soon.